let's go ahead and get started. I know most of you. I'm Rob McConnell. I'm a professor in the Department of Population and Public Health Sciences, and welcome to our periodic seminar series, Be Heard, that's intended to help people communicate better their science and to have a bigger impact on policy and other outcomes related to policy. Today's a special treat. It's something that we aren't usually taught very much about, and it's tort law as an underappreciated policy tool for regulating exposures. So I think I'll stop here so we can get to the meat of the discussion, and Sofia Gruskin is going to moderate the session, and she'll introduce the two panelists.
Great. Hi, everybody. It's great to be here, and I'm looking forward to the conversation, I have to say. And Rob, I want to say, first of all, I'm grateful that you suggested I moderate this. I assume it's because you wanted it to be handled by a lawyer. So I'm happy to do so. But I want to say that for me, law is a very important tool for public health. I mean, laws can help and they can be steered to improve the public's health, but laws can be super harmful to health. And it's something that I think that's getting increasing attention to these days in a whole lot of areas. And the focus today on litigation, right, and tort law is really a critical component of this law and health connection. And I was really excited to get to know our two speakers through this preparing for the webinar, and I think you both bring really important and complementary pieces to the puzzle. I wanted to tell people that the way we're going to do this is in a Q&A format. So I'm going to pose some questions to our distinguished panelists, get their responses, and then open it up to the rest of you for questions that you might have. So if you'll allow me just two brief introductions. So Gary DiMuzio is an attorney. He's a partner in the asbestos department of Simmons, Hanley, Conroy, and he really has incredible experience litigating cases that involve environmental and workplace hazards. He is a wealth of knowledge in how to do these cases. He's literally litigated hundreds of these cases against some of the nation's largest corporation. He is a lawyer's lawyer, I want to say, in the best sense of the word. So Gary, welcome. And Steve Markowitz, who's an MD and DrPh, is an occupational medicine physician and professor and director of the Barry Commoner Center for Health and Environment at Queens College, CUNY. And here, too, we really genuinely have a giant in the field, someone who has studied and addressed asbestos-related diseases, including mortality amongst North American insulators in ways that have really changed the legal landscape for the better. Dr. Markowitz has testified as an expert witness in countless tort cases involving asbestos, but also other diseases. He's truly our expert witness. So Stephen, welcome. And with that, I want to begin with my first question, if you will allow me, which is, can I ask each of you, just to situate this, because what you do is different than what people here really all know about. Can you tell us what you do, your typical day or week, just to set the stage, and what motivates you to do this work? Stephen, you want to just start first, because I see you?
Sure. Yeah, I'm a professor, City University of New York. I run a research center, the Barry Commoner Center, and much of my days is spent running a national medical screening program for nuclear weapons workers who work throughout the DOE complex across the country, have developed occupational illnesses. And our special effort is we do lung cancer screening, and have done so for 2 decades, actually, of these workers who have been exposed to radiation, asbestos, silica, beryllium, etc. And many of them smoke. In our center, we're about to launch special air pollution monitoring to look at congestion pricing. In New York City, we've been monitoring air for the routine criteria pollutants over the last 15 years or so. So that's what I spend my day doing. Gary? And I'm sorry, Sophia, I can come back to what motivates me to do this, but let Gary explain his typical.
Okay, let's do that, and then you can talk about motivation. That's awesome. Okay, go ahead.
Okay, thank you for having me. I'm Gary DiMuzio. I'm a lawyer with Simmons Hanley Conroy. I've virtually my entire career, I began practicing in '94. I've always done some form of toxic torts as the predominant practice that I've had. Starting from grunt work, where's the lost medical record, et cetera, up to trying lawsuits and dealing with Congress and things like that. At this point, I'm pretty much considered just a trial lawyer at my firm, meaning that I do get to skip a lot of the grunt work and basically either try the lawsuits or deal with the critical preparation for the lawsuits. Mainly would be critical expert depositions of both my side and their side, the other side, and then dealing with the corporate rep deposition. So that's a lot of what I do. And because I'm responsible for the trial, I guess there's two goals with every trial lawyer: win and then have it hold up on appeal. That's really my thought process. And although there's a lot of balls in the air with these things, it's amazing the more complicated things get, how you have to come back to the basics over and over. And at the end of the day, what I do almost every day is I think, what's in my actual complaint, the lawsuit that I filed? What are the causes of action? What do I have to prove? And how do I prove it? What witnesses do I need? And, how do I stop the other side's witnesses from knocking my sandcastle down? And what documents do I need? And how do I get them into evidence? Because a great document that's not admissible isn't going to do you any good. So that's the sort of thing that, really takes my time. I guess most particularly dealing with the experts. I serve as a bridge between the lawyers who worked up the basic facts of the case and them, so that they have what they need to either comment directly on those facts or comment about a kind of a similar hypothetical situation. Sometimes is the way experts will deal with these things. And so that's pretty much it, making sure my experts have what they need, making sure I can attack the other side's attack on me, a counterattack, and then also getting some of the critical proof components out of the company itself. Did they make a product with the bad stuff in it, right? Did they know, or should they have known? Things like that. Did they warn, or was the warning inadequate? That's pretty much my life. That and actually dealing with those depositions and then going to trial.
Okay, that's super helpful. And I think it's super helpful also in terms of painting the picture of what's involved. Stephen, can I go back to you just really quickly in terms of motivation?
Sure. So, I trained in internal medicine, actually with Dr. McConnell in the 80s, and then trained in occupational medicine at Mount Sinai, where Dr. Selikoff, the great asbestos researcher, was. And so I sort of fell into tort litigation a few years later because I knew a lot about asbestos. But let me say that I think that many health professionals think of tort litigation as kind of an unsavory or distasteful activity, that you've got lawyers who are ambulance chasers, you've got experts who are prostitutes for either companies or plaintiffs, you have company shills who just want to protect companies' interests, etc. Well, that's one view. But let me say that I don't think there's a whole lot of truth to all that. I'll give you an example. I want to change the lens a little bit. Talk about a recent one or two cases. By the way, I have not testified in countless cases. I testify once or twice a year. So I just want to set that straight. But nonetheless, I've been doing it for a long time. So I may want to talk about this. But so recent case, I'm going to disguise the details so it's not identifiable, but 74-year-old person who immigrated from Eastern Europe to the US in the early 70s, had done some woodwork and came here and was essentially a carpenter for his career, and spent the first few years applying joint compound in the 70s to sheetrock walls, sanding it, breathing in the dust, and also fixing fire doors. Fire doors at that time contain an asbestos laminate inside the door in order to protect from fire, of course. Never told really that asbestos was dangerous, and now age 74, a year or two ago, develops malignant mesothelioma, which is the cardinal cancer, so almost always caused by asbestos. This is the lethal disease. He's 74. He's a 74-year-old man in the US. Life expectancy for a 74-year-old man is 14 years. If he were 80, a bit older, it would still be 8 years. So without mesothelioma, which most people die from within a year or two, he would have lived 14 years total. And yet he's sick and has no recourse. If he's lucky, he seeks out a good center so he gets better care. But he has no recourse about what the injury that that he's incurred. Recourse in terms of, in any sense, reversing it. He can, however, engage in a lawsuit, and he can get some, for what it's worth, compensation, which will help his family, his spouse, partner, after he dies, and will be, I suppose, some measure of justice. That person needs a lawyer. They need a lawyer who knows what they're doing. They need a lawyer who's not going to cost them $50,000 up front. And that lawyer needs a health expert who's going to essentially explain to the jury what asbestos is, what asbestos does, in terms that a jury can understand. And that's a challenge because you're talking to, a dozen lay people who have no sophistication in science, who have their own set of prejudices about the world. And you need to explain, because they're the decision makers. They're the ones who's going to decide what happens with this person. And so as an expert, the job is to explain it in those terms. That's, in my view, the most important aspect of it. And it's challenging, and I think it's really worthwhile to the many people who are affected this way.
Gotcha. I mean, I want to take us back, Gary, if you don't mind, because I feel like we're throwing a lot of terms out, and I want to make sure that everybody is at ease with this. Do you mind? Can you just say just a little bit in big, like, what is a toxic tort? Like, can you specifically talk about it kind of in that way to help kind of set the scene for the rest of these conversations? Is that okay?
Sure. Well, toxic, pretty obvious, right? The standard meaning out there. Tort may require a little bit of explanation. A tort is some form of harm, a legal remedy for a form of harm. For example, if I punch you in the nose and you bleed and you have to go to the hospital, you have a tort action against me. You might have a criminal action too. It really wouldn't be yours. It'd be the state coming after me. But you could sue me in tort for those damages. And in a toxic tort, obviously, we're talking about a toxic material doing that. And there are several things that one has to prove there. And number one, reminding of what Dr. Markowitz said there, I'm a lawyer. All I can do is argue. I'm not real. I don't have evidentiary force behind what I say. I'm just there to sort of be a circus ringmaster and frame the arguments for people. But what I say is not evidence. What Dr. Markowitz says is evidence. So that's a very important distinction there. In terms of the toxic torts, it's not enough just to say, okay, I'm hurt, I got exposed to some bad stuff, and company X is down the street. You're going to lose your lawsuit if that's all you got. And the way our system works, and this goes right back to the Middle Ages in England, is that you have to allege causes of action. And every one of those causes of action is going to have a certain set of bullet points underneath them that you've got to prove up, elements that are critical there. And it might be worth talking about a couple of the big ones here for a moment. One of them is negligence. You're basically alleging that the person's behavior was not what it should have been. They didn't meet some safety standard, or they broke a safety rule. And now you are suffering the consequences of that. And in terms of needing expert testimony, it's the four elements of a tort, any tort, including me punching you, is duty, breach of that duty, causation, and damages. And every one of those elements requires expert testimony and fact testimony both. So again, I'm sort of beholden to these fact witnesses and expert witnesses to come up and do those sorts of things. There was one major, and this kind of gets into the big policy thing about how law has evolved, I think has been good in evolving public perceptions and public policies. In the bad old days, there was something called contributory negligence. And what that meant was no matter how bad the company was, if the individual contributed even just a teeny tiny bit to the harm, they would completely lose the lawsuit. It was a complete bar. And so it made something like asbestos cases or silicosis cases impossible, because they'd say, well, you might not have known that dust would give you cancer, but you knew dust wasn't good for you, right? Yeah, boom, you don't have a lawsuit anymore. I mean, that's how strict it was. There was a change in the law, and it really involved products liability law in the 1960s. And what that change was is that instead of looking at the company's behaviors, they looked at the product. What's the nature of the product itself? Is the product so dangerous and so dangerous beyond the experience of normal people that they should be held responsible for it, even if they more or less were not negligent, right? They just went out there. So that was a huge change in the law. Suddenly we could file these lawsuits. That's why these lawsuits started in the early 70s. That change in the law occurred in the 60s. It allowed this to go forward. And the only defense to this, and this is kind of an interesting twist that really surprised me as I learned this area, the only defense to the strict liability in most jurisdictions is if they could prove that it was not knowable, that it was a dangerous product, not knowable at the time. So they're charged with the duty of an expert, and you got to find out whether it's knowable or not. So when you start going back into the history of this and you start reading about who knew what and when about the dangers of asbestos, it really wasn't plaintiff lawyers like me pushing that. It was the defendants, because it was their only possible way to avoid liability. So they would try to spin these facts in a way that would make it look like, well, I mean, as far as I'm concerned, by 1930, we knew you should warn about asbestos. We knew it caused a fatal disease. We knew you had to educate the workers, give them a sane appreciation of the risk, is the cliche from back then. And, that was the end of the story. But now they need to pitch that story in terms of we couldn't have possibly known. So they come up with all these side stories like, well, maybe we knew asbestos could hurt you, but you didn't know asbestos in my product could hurt you. Or the asbestos in my product is encapsulated in rubber or some other material, so it can't. So those are the sorts of things we deal with. And that's basically what the torts deal with. It's usually a personal injury type of a case, but you can also have torts for property. Did the contamination ruin your yard and your home? Are you going to have it remediated? Are you going to have to move? But it can encompass both sets of damages.
Again, super helpful. Again, super helpful. I guess, one of the things I'm really struck with is that this is an audience of mainly public health researchers and people who write articles in the peer-reviewed literature. And I guess it's a question to both of you really about the value of peer-reviewed literature for doing this sort of work. How does the literature get used in courts? And then I guess, again, a question to both of you related to that is, if you wanted to say, this is how we could make published pieces most useful for this kind of work, what would that look like? I mean, is it about the conclusions in academic papers? Is it about making a convincing case? Because obviously it's peer-reviewed academic work. So it's really a question about how it can be most useful. I don't know who Stephen, you want to start on this one? Is that okay? And then we'll go to Gary.
Yeah, sure. Well, so I'm there to interpret the science and explain it. And the science that I talk about comes from the peer-reviewed literature. That's the basis. There's also a gray literature that can be used. It's helpful sometimes, but the real basis is the peer-reviewed literature. And as an expert, I'm there to discuss it. And what's interesting about it is taking kind of general things that we learn from studies and then applying it to an individual person and the particulars of that person. And that can be challenging, actually. Peer review per se has some special legal status in the expert world, which I'm going to let Gary explain because I'm not sure I totally understand it. As far as how we write articles or how we interpret articles, to me, it's a question of clarity, particularly in the conclusions and in the abstract, that the writing should be as clear, as definitive, as conclusive as possible. understanding that there are multiple audiences. Actually, you think you're mostly speaking to your peers, right? Other people who are doing this work or related work, but actually there's a broader audience. And it's not just in the tort litigation, it's in the regulatory world, which depends also on this peer-reviewed literature. So my view is just this clarity in conclusions being as definitive as possible based on what you found is the most helpful outcome. Gary?
That's great. And once again, when it comes to this material being presented in the courtroom, Dr. Markowitz is the real authority because that's the only thing that counts, right? Everything I am talking about is trying to frame it, or as many people, lay people think, trying to trick them into, going my way, so to speak, right? So, I mean, and admittedly, I'm biased. I'm an advocate for my client. There's no ifs, ands, or buts about it. Not that ethically allows me to engage in trickery, but the bias is real. There's no question about it. Going back to what I said before about the various elements of negligence, by example, all four require expert testimony, but probably the most interesting one here that I can quickly delineate would be causation. Did that behavior cause the harm? And then the behavior, of course, becomes the exposure. Right? Exposure is a huge part of that. And so what would we need to do to prove this? And to one degree or another, we need exposure information. It can come from a normal doctor. They do that. They take histories. But oftentimes it's an industrial hygienist, oftentimes a certified industrial hygienist, producing information saying, yes, these types of products under these kinds of conditions will produce exposures. And so that's going to be a key aspect of it. You might, depending on the case, need some sort of a toxicologist or a fiber biologist. What do fibers do when they get into the body? Or sometimes an epidemiologist. Sometimes certain arguments are made where it's handy to have a full-blown epidemiologist. For example, okay, asbestos can kill people, but you don't have any epidemiology studies showing my particular brand of product has killed anybody. Well, you've got to cut through those arguments, and that can be a bit complicated. I said it in a kind of a dumb way that everyone here immediately saw through. It's a more sophisticated presentation of that basic idea in court. So that's a lot of it. Now, in terms of peer review in particular, it's one of the elements of a very important case called Daubert. And this is a different aspect of the law. Not only do you need, first of all, you need the scientific evidence or your case is going to fail. You have not only a chain of causation, but a chain of liability. And if the defendants can snap any one of those links in the chain, I lose. So very important to have this be on solid ground. In the old days, most jurisdictions use what we call the Fry rule, which is just, is it generally accepted? If it's generally accepted, the jury can consider it. The Daubert rule ruled that could be too strict. For example, the theory of relativity was not generally accepted at one time, but it was right. Right? So Einstein was in a minority, but he was correct. So the Daubert decision, it basically said you can't use general acceptance as a threshold requirement. But then the judge, the Supreme Court Justice Stevens, he gave a series of what I would consider dicta, not the holding of the case, but just an explanation of things that you might consider, like the rate of error and whether it's repeatable or not, and whether it's been peer reviewed or not. That's one of the elements that he specifically mentioned, et cetera. So that's where these things come into play. And it's very important because think about it. If this is the judge making a ruling as to whether the jury is going to see this or not. So if the jury sees a lot of information in a total scope of all the issues about how badly the company behaved, they're likely to nail the company, right? I mean, the more they hear about the case, the less likely they are to give a defense verdict in most situations. The problem with Daubert is that it happens before a jury walks in the courtroom. And if they can win and show the defense can convince the judge that some of this critical element is not reliable under a Daubert analysis, the jury never hears about the bad behavior. So it's the perfect defense, right? The jury never hears about this stuff. In fact, all the other advantages of litigation, like being able to discover in detail what they knew and how they found out about it, et cetera, which can help prevent these problems in the future, it goes away too, because there's not a dispute anymore. The plaintiffs can't prove it. Their evidence isn't legitimate. So it's the peer review is an important aspect of that. The problem is, I think we all know that peer review has its limitations. It basically just means you're in the ballpark. It's probably what most of us think, that, you know, a superficial look by people who may or may not really be qualified seem to think that this is okay. It's become, for some judges, it's like, oh, it's not peer reviewed, we're not going to talk about it. And similarly, the defendants have been very, very good about lobbying behind the scenes in all sorts of public health areas. In that now you really cannot rely on a lot of old data that was produced in the old days that might not have been peer reviewed. So the only thing you can rely upon now for like risk assessment for asbestos are peer reviewed articles. What's the problem with that? Well, the good guys aren't out there spending a ton of money on this stuff. They're doing other things with their life. Who's spending money publishing these things? Industry, right? They dominate the publication. And in some ways, they're poisoning the well of scientific literature by, you know, a great expense. Ford, last time I checked, is spent somewhere in the neighborhood of $40 million producing asbestos literature through 3 or 4 what I would call defense expert boutiques. Well, that's what they do. They just don't get in the courtroom and testify. They're producing literature that then they throw in Dr. Markowitz's face and go, "Isn't this peer reviewed?" It's an effective push.
You know, and it's happening in so many areas of public health right now in terms of just the industry capture of not only peer review, but also actually buying journals, right? In terms of all of that. So
yeah,
totally.
you see the same journals, inhalation toxicology, critical reviews in toxicology, over and over again. And then the other thing that they do, besides being published, is we all know one thing that you rate the value of an article or a book on is how many professionals are looking at this, how many of them are citing it. Well, they all cite to each other, right? So all these stout scientists, they're all paid by the same people. They publish this stuff, and then they start citing each other's literature. So suddenly all the indicia of reliability starts to go up for them. And meanwhile, we have nothing to fight that with on our side.
I don't see what we can do about that, actually.
It's tough.
If the industry's entitled to pay for science and pay for studies, I don't see within the scientific world any way to regulate that. I wonder whether in the legal world, by judges or whatnot, there can be somehow sorting through what is a legitimate group of studies to cite or not. I don't know if there's a legal solution to that, but I can't think of any scientific solution to that.
So can I
go ahead.
Just to say on that, I mean, I know in another space in reproductive health that I know that one of the things that's been really important has been for people to actually go after the science and get journal articles retracted because the science isn't strong enough. And there's been a lot of efforts from people, let me say the good guys on our side, trying to do that in terms of what's happened with some of the industry pieces. And so I just put that to you. Sorry, Gary, go ahead, but I just put that to you as
well, along those lines, for example, there's a form of asbestos called chrysotile. The defendants like to say it's the friendly fiber. It doesn't cause mesothelioma. Unfortunately for them, there's lots of evidence that it does, including some pure chrysotile mines that are not contaminated with other forms of asbestos. And so several defense experts, it's a very long story, which I'm happy to talk about in detail in another forum, but they actually published an article saying, oh, you know, they actually used a lot of amphibole type asbestos at this mine. Why would you use asbestos at an asbestos mine? Sort of doesn't make a lot of sense. But they tried to make that claim, and they tried to claim that it was naturally occurring as a contaminant or, you know, a co-formed mineral at the time this was. Now, the problem with this is that, you know, they were saying, and by the way, there's evidence that this stuff was brought to the mine, you know, and they had a footnote for that. Well, fortunately, the Italian researchers who lived in this area at the University of Turin and know all this knew this was all complete bunk. It had never been used. It's not part of the natural geology. And they published some letters to the editor. I don't think the article was actually retracted, but it was pretty serious mud on the face for these. And two of the four authors were fairly well-known defense experts who show up in the litigation a lot. So, that sort of thing does happen. But I think the biggest problem, and this gets into how do you persuade juries and judges, and even some of our own experts and people who mean well, they want to think that it's one person's word on the plaintiff side, and he's making $500 an hour or $1,000 an hour, and he's going against another well-paid expert on the defense side who's also being well-paid. So it's one well-paid expert against another. It's a battle of the experts. That's not what's happening. This is the tobacco model. This is a few very well-intentioned, highly qualified people like Dr. Markowitz going out there and testifying when they could probably be doing better, less headache sort of activities in academia, but are good enough to get in there and try to help these people get compensation versus an industry. Millions and millions of dollars. And besides the millions of dollars of producing this stuff, they engage in focus groups to see what's the most effective sort of angle for our literature to take, and what's the most effective way to spin this, not just to win for jurors, but what's the most effective way to convince agencies and juries and judges that, we're right. So it's an industry. That's what it is. It's not man against man, mano v mano. That's, it's not a guns fight and OK corral. This is an industry against a fairly small group. David versus.
I think a solution, and we can move on. But I think a solution is that the government should require that industry contribute to an independent fund that does research on relevant issues, and that independent fund is not controlled by any party on either side, on any side. It examines things dispassionately to come up with unprejudiced science. I think we need to separate the research from the industry, from the producers, because they have a built-in conflict.
Yeah, I mean, and just to say, as somebody put in the chat, journals typically require that authors should cite kind of their how it is that they're funded, and that is something that's more recent, really, in terms of being able to do that. But it's also how that's taken in. I want to move us on, though, if I can, because I could get into this part of the conversation. You both mentioned juries quite a bit, and the fact is, juries are made up of the general public. And I guess really the question really is, there's such complexity in the issues that you work on, Stephen, basically, in terms of that. My question to you is, what's needed really for the general public to understand the complexity of the issues and why it's important for public health? And then Gary, for you, how is it that language and that complexity gets translated in terms of so that the jury can hear it and can understand it? Stephen, would you start?
Yeah, sure. If you have a chance, when you have a chance to serve in a jury, you definitely should, because it's fascinating. It's fascinating. You're thrown in with a group of strangers, all kinds of backgrounds, levels of knowledge, etc., who are charged with making a decision, and you see the way people make decisions under those circumstances. I've done it twice. Interestingly, once was some sort of lawsuit against the MTA, and I was sure that they would not pick me because I'm sure the MTA side would not pick me because I'm a so-called plaintiff's expert. And they picked me, and I was the strongest voice in favor of the MTA because I could sort through the facts and straighten them out. But in any case, normally we teach each other, right? We teach people who have a lot more knowledge than the general public. They understand the terms. And we're not really challenged to get outside of our realm of knowledge. Juries is something else because they're the decision makers, as I said before, and by law they're entitled. They need to make a decision, and they should make the right decision, whatever decision that is. They should make the right decision. So my job in a few hours up there, and by the way, I don't get to give a lecture. I only answer questions. So if one side or the other asks me, whatever they ask me, I answer. I don't get to, oh, you forgot this. And then let me say this because this is needed to understand. It's nothing like that. And the other side, when they're questioning me, they're not necessarily interested in elucidating things in the kind of way that would break towards the plaintiff. They're not necessarily hostile questions, but in some sense, they're trying to disprove what I say or question my expertise or something like that. So it's in that context that you're challenged to give this jury, this naive group, enough information to make a decent decision. And that's interesting, I have to say. As a teacher, that's interesting because if you take it seriously, if you're not just up there giving, the lecture that you had in mind for the last group of whatever students or whatever you spoke to, but you take it seriously, that's not easy and it's challenging and it's I think worthwhile in the process.
Great. Gary?
Sure. Just one direct comment on Stephen's comments there. I think all that is solid, good advice that's out there. And in terms of asking questions and only responding to questions, that has become an art form. I think on both sides of the aisle, but particularly with the defendants, because the science doesn't really go their way. So they have made an art form, i.e., like trying to pretend that the history means that they couldn't have known about the dangers of asbestos, despite 650 articles being published prior to 1965 in the literature they couldn't have possibly known. They've gotten very good at cherry picking their questions, and I think people like David Michaels, former OSHA director, epidemiologist at GW, who writes on Doubt Science, he's made a comment to the effect that a lot of times it's really not the conclusions of the papers or what their scientists are saying, it's that they're posing the wrong questions. You find a lot of straw man arguments out there. So they'll try to pretend that this is the real issue. It's the straw man. The straw man is incorrect. Therefore, I win. And meanwhile, they're missing the whole point. So it's a very dangerous thing. In terms of persuading jurors, I think I have a bit of an advantage over, say, politicians, in that I'm not limited in time to little sound bites here and there, and I'm not limited to the media asking the right questions or doing the right follow-up. I can control that. I've got that jury in the box for 1, 2, 3 weeks. And I can create my own little world where I think they get my story and I can frame my story to them. And I get to do that before the defense does. So I think that's very important. People who might politically lean against my way of thinking on these issues might go my way if they hear the whole story. Some people, jurors are generally good. I'm a believer in the jury system. I think that's a really important aspect of this stuff. In terms of convincing them, it's critical that the issues be framed appropriately and honestly. Any dishonesty on the part of a plaintiff lawyer or their expert is the kiss of death. They actually kind of expect it out of defense lawyers and their experts, and they will forgive them. There's a much higher standard for plaintiff lawyers and plaintiff experts. There are a lot of defense experts testifying now who, if they were plaintiff lawyer experts, would be zombies. I mean, they have been killed so many times in trial, and yet they just come back over and over and over again. Another important thing is that these are complex issues, and you have to don't sound like a know-it-all. Don't use a bunch of acronyms. Keep it simple. Instead of trying to act like a big shot lawyer, try to be like the local neighborhood mechanic who's going to go help somebody buy a used car. That's what you're doing. Or your favorite 5th grade science teacher. That should be the goal for where you're shooting from. Your stained glass light should be coming from that sort of a prism. You should use examples. A critical issue for us is, do all exposures count, or can you ignore some exposures? And they always want to say, well, yeah, maybe asbestos caused it, but it was all that other asbestos. It wasn't the asbestos from my product. And you need to be able to use analogies that resonate with them. For example, to me, I'll tell a jury, that's just like saying, you know, I went out drinking, I had 2 scotches, 2 whiskeys, 3 gin and tonics, and a bottle of wine and 5 beers, but the beers didn't matter. I mean, they all know that's nonsense, right? I mean, you need to be able to some extent bring it into their realm and show it to them from that aspect. I think you need to go ahead.
Did you realize that the evaluation after this seminar includes a question of, would you buy a used car from Gary Muzio?
If the answer is no, I lose the case.
Sorry to interrupt.
Yeah, so that's right. So I think, and I mentioned some of this already, so I don't want to get too elaborate about it. I think the bias issue has to be brought up, and you got to force the judge to allow you to do that. You've got to show this isn't an honest, you know, okay, here's your side of the story, here's your side of the story. That's a false equivalency. You don't want to allow that to occur. Think 60 Minutes, the old 60 Minutes news program. I mean, in 60 Minutes, they could completely fry a company and you would believe it and know that they were bad. You know, litigation, it takes us 2 to 3 weeks to do the same thing. But to me, that 60 Minutes model is a key one to do that sort of thing. And then another thing is, besides the money and the bias, I like to point out my experts, like Dr. Markowitz, their day job is serving the community. They're there to treat patients. They're there to make diagnosis. They're there to go in front of Congress and say, we need to keep this bad stuff out of people's bodies. And that's what they do. What are the other side's experts doing? Many of these people have never served in academia. They've never served in a public health agency, but they're very well paid. And they usually have PhDs and MDs. So they're qualified. Most of them are qualified to be doing what they're doing. And I think you need to point that out, you know, the bias generally, and also let's compare, you know, what we're dealing with here. Yeah. Does the person really know, or are they basically a failed emergency room doctor who decided they could make a lot of money by working in these Dow science boutiques, which happens? You know, my best cross-examination ever was a failed emergency room doctor who had gone to work for one of the big bad outfits who shall remain nameless. And all I did was, at one point, before they could ask him questions, I asked to go over his credentials with him, showed that he hadn't published in asbestos, he had never treated an asbestos patient, never diagnosed anyone with mesothelioma, had no background in epidemiology, toxicology, and did no publishing until he was being paid to do it. And so when they finished their direct, they asked me, you know, Mr. Muzio, time for you to ask your questions. I just stood up and said, Your Honor, no further questions at this time, and sat down. And the jurors who we interviewed afterwards said it was demolishing. They couldn't believe they even brought this guy, given his complete lack of credentials. So that's what you got to show. Compare that to Dr. Markowitz, who's at Mount Sinai, working with Selikoff on the original cohorts that really proved that these things were causing disease in the population, and still following up on that today. You've got to do that compare and contrast.
I love the way you work with juries. That's fabulous. You were talking about simplification. That's a simplification that works incredibly well. But, you know, also that point about credibility, kind of what you were saying about, you know, that kind of toggling between the two. I have one last kind of big question that I want to ask all of you, and I have a lot of others, but I want to be able to open it up to other people to be able to ask questions as well. So if you'll allow me, everybody, to just ask my last question to our speakers, and then please be ready with your own. And, you know, and it really comes from this dialogue that we're having, you know, what, I guess, Gary, first to you, like, what can folks from the public health, from the medical side do to make things easier for lawyers working in this area? Like, what would be helpful to you? And then kind of on the other side, you know, are there things, Stephen, that you want to say about kind of when you think about law and lawyers in terms of the writing that folks in public health do, in terms of kind of the research they do? Are there things that are to be learned from lawyers that could help, and where it would actually kind of make your job, our jobs, easier? What I'm getting at is, we tend to speak past each other in these kind of two different spaces. So how do we work together to be most complementary to make this work? We're all going after kind of the same thing, right? We're all trying to do this. And so, yeah, if I can ask the question in that way.
Okay. And did you want me to answer first?
I did. Sorry, if you don't mind, that would be great.
Sure, that's fine. Yeah, I think the language is the issue. I mean, it's the Tower of Babel problem. In fact, in some ways, it's worse because we think we're speaking the same language, but we're defining terms in different ways. It can be very, very confusing in that regard. So I think that's something to think about, right off the bat. Second of all, I would point out that in my opinion, the problem is really more on the lawyer side than the public health side. I'm a public health person. I think public health background is perfect for not only public health, but the courtroom. Because think about it, this is an interdisciplinary area. And it's not enough if you're the greatest epidemiologist in the world, but you can't understand what a diagnosis is. And I understand that nowadays that probably wouldn't happen. You wouldn't come out of it. But people can become hyper specialized and not understand how their testimony hooks up with someone else. So in some ways, having a public health background, being forced to take classes in statistics, epidemiology, toxicology, exposure assessment, it's a great thing. And like a classic argument against a state-of-the-art expert would say, well, he's not a medical doctor, or he's not an epidemiologist, or he's not this or that. It's like arguing that a presidential historian has to have been the president. Well, probably most presidents would be terrible presidential historians. It's another role, and it's an interdisciplinary role, right? So I think that's a big part of it. I think the language that gets used sometimes, or that a lot of doctors fall back into, can be really problematic. For example, they say this is consistent with blah blah blah. Well, that doesn't win my trial. Being consistent with something is not. This is a lung cancer is consistent with asbestos exposure. You got to say that the asbestos exposure caused that lung cancer, in part at least. So that's something that doctors in particular want to fall back to these stock phrases, which makes sense, right? You're kind of covering yourself for future literature and blah, blah, blah. But again, in science, you're trying to come up with proof that will stand the test of time and be in the peer-reviewed literature for a long time. That's not the purpose of proof in a courtroom. We're here to resolve human conflict now. You've got to make a decision now. And I think that's something that public health and especially medical doctors need to take into consideration. One real problem in terms of defining things in unclear, difficult ways, which I would blame on both sides, but I would lay the responsibility at the feet of the lawyers, is terminology like substantial contributing factor. That's a term that gets used a lot. Is the exposure a, quote, substantial contributing factor to this man getting mesothelioma? Well, first of all, that's nothing that you learned in public health or medical school. It's not really a scientific term. It's a medico-legal term, right? It's a term of art. And it changes from state to state, something many lawyers don't even know that. They don't know that, for example, in some states, substantial contributing factor just means when an expert looks at it, he hears about the exposure and the totality of the exposure, he thinks that would be a significant portion that he would be concerned about from, say, a public health standpoint. That's really what it was originally intended to mean. There have been some states that have had decisions that say, no, you've got to quantify that. You got to explain how often was the product in the workplace, how often was the worker in the workplace, and what was his proximity to that. So it's the same term, but it has a completely different definition. And a lot of times I've read transcripts, usually after the fact, unfortunately, and in the trials, where I see that the lawyer never told the expert what the actual standard was. And it makes it rife for a really smart defense lawyer who knows these games to cut them to pieces afterwards. It's the job of the lawyer to know that and to make that the round peg and square hole, the science into the law has got to fit. It can work. It can be done. You can put square peg in a round hole, but it's got to be massaged appropriately, and the expert needs to do that. And I think it's the job of the lawyers to make sure the experts understand what the burden is and what the terminology really means.
Stephen, does that resonate?
Sure. A couple of things. One is, of course, Gary knows physicians could care less about causation because it's not what we do. We do diagnosis and treatment. Public
Right.
health scientists do causation. The people who are attending this seminar do causation. But I want to raise a related point. What's the importance of this tort litigation in the bigger picture? I mean, how do we control corporate behavior? Corporations are the ones who synthesize the new chemicals, thousands per year. They're the ones that develop and market the products. And they have their own statement of principles. I think everyone would agree we probably shouldn't rely on self-regulation by the corporations because their job is not necessarily to promote safety. Their job is to sell products. Fair enough. So we have regulation. So the government regulates the corporate behavior, and more or less, depending on the fads and whatnot. Of course, corporations very much influence regulation and how it comes out. So it's usually watered down. And by the way, let me give you an example. Asbestos was banned 3 weeks ago by the EPA. Asbestos. We have tens of thousands of people who develop asbestos-related cancer per year in the country. We knew it was bad decades and decades and decades. It's really actually a century ago. And now it's only being banned, only being fully regulated. So we can't rely on regulation entirely. It's a tool. And tort litigation is a tool because it speaks the language that companies understand, which is that it costs you money if you don't properly warn workers or people in the community or whatnot about how their products can be harmful. And if you don't take, as a corporation, appropriate actions to prevent that harm, to prevent water supplies from being contaminated with PFAS and the like. And though it'll cost them money in tort litigation, and you've seen the headlines in the various cases, it costs them billions of dollars. That's a language they understand. And so tort litigation is a very important tool in public health to get to where we want to go.
Right. I just very quickly, go ahead.
No, it's not the only tool, obviously, but it's a tool that we should attend to because it does help us make progress in public health.
And I'd just like to hop on that for a moment. It's faster than regulation, generally speaking. Not always. The wheels of justice grind slowly, but it's generally a lot faster than regulation. And it has a more democratic, purely democratic aspect to it because a jury comes in. When you're dealing with agencies, we have the agency capture issue, et cetera, et cetera. Here, it's just your average Joe Americans sitting there and they get to hear both sides of the discussion. And it's so effective in the case of asbestos is that although it was not banned, there has been a de facto ban. I mean, there hasn't been fireproofing used in this country since probably 72 or 73 because of lawsuits. And many of the insulation products were pretty much phased out by the end of the 70s, and very few products have been being used. And it's because of that. It's because they're no longer allowed to externalize their costs. And when they do externalize their costs the way they have, and my clients have to bear that cost is much higher than if they had done the right thing in the right way at the beginning. So it's a big, big thing. And it really does affect corporate thinking. For example, when there were internal corporate discussions about vinyl chloride, when they started noticing it was causing cancer and having systemic effects, they almost immediately pulled it out of products like hairspray. Vinyl chloride was used as a propellant in hairspray. They pulled it out because hairdressers could sue them. But they kept producing it on the industrial level because they didn't really care that much about their workers. Workers are covered by workers' compensation. They can't sue in the civil system where you can do discovery to find out what they knew when, where's the bad behavior, and you can get damages for things like, mental distress, et cetera, a whole range of damages over and above just the pure, what's your wage loss and how much did your funeral cost, which is pretty much.
Oh, sorry. But just to say, we're running out of time, and I want to make sure that people have an opportunity to ask questions if anybody has a question to ask. I'm looking to see, is anybody going to put up a little hand or put their camera on? No. Well, we can keep going then. In that case, I just wanted to make apps.
I have a question.
Please.
So
and there's another question as well. So go ahead. We'll take both questions.
Some of us occasionally get an invitation to to be an expert witness. If you've written a paper about something that a case that a lawyer's interested in, you might hear from someone looking for an expert witness. And I know, Stephen, I've thought about doing some of this in the past, and you gave me some sort of some good words of caution about things that you need to think about before you accept an invitation like that. I wonder if for this audience, because people get these invitations, they might be inspired by the discussion today. If you could give people some advice about how to go about this if you want to get into this arena.
Yeah.
And let me take, before we do that, if I may take the other question, so we have both
Sure.
questions, and then we'll wrap up. So please. Yes, please.
Okay, I just had, how does the tort law works with public agencies who are allowing, say, pollution disproportionately affecting one particular community, like the ports in particular? How does this work? How does that work? Is it the same? Is the process the same? Or is it different because we have a public agency who's a landlord allowing pollution to come into the community and giving premature deaths? So
Yeah.
how does this work?
Those are excellent, both of them excellent questions. So, and may I just say, Gary and Stephen, this is your last shot. All right, in terms of, so whatever else you feel like you want to say, please go ahead at this point, okay?
And maybe I'll withdraw my question and just say, if anybody gets an invitation like this and is interested
Don't
in
withdraw it, Rob. Don't withdraw it.
That's a great question.
Yeah, don't withdraw it. Like, let's just hear what they both have to say and then see where and close up from there.
Well, yeah, I can quickly handle Rob's question. Judges sometimes instruct you to answer the question yes or no, and leave it at that. So I'm going to say yes, but the thing is that I'm generally speaking conflict adverse, but in that setting, you've got to be willing to take on hostile questions and get used to conflict. I think it's beneficial actually, because it kind of toughens you up, toughens up your thinking actually about given issues. Mind you, you're always under oath to tell the truth, right? So you really have to think things through, whatever the question is. Other than that, I don't necessarily have much encouragement. Gary, you want to take on the second question?
Sure. Yeah, this idea of disparate approaches based on income or race and that sort of thing, it's been talked about for a long time, and it's true. For example, and it's interesting, sometimes public health has not really fulfilled its responsibilities either. If you look at silicosis, it's a very good example. In the 20s and 30s, it started becoming clear that we had virtually a silicosis epidemic in the United States. And very clear that was what was happening. And yet they managed to get the public health people, the defense, the industry, to really back off blaming silica for it. It's very similar to tuberculosis, which was also around. And the germ theory was the hot scientific issue back in the 20s. That was the sexier thing to talk about. So it became very easy to get the public health community to buy into industry excuses that it's not the silica, it's the lifestyle of these people. They're living in close proximity and giving each other tuberculosis. It's not that. And
but
so,
Gary, can you sue a public agency that's doing what?
Yeah, but it's extremely difficult in this sort of a situation. You can sue them, but it's sort of the same song and dance of, and when you look at who was getting silicosis, well, in the early days, it was in the Northeast, and it was everybody. It was all the workers in the more industrialized Northeast. By the 30s, they started having unions and they had some politicians who would do their work for them. So what did industry do? They moved to the South, where they had blacks and politically disenfranchised whites. And that's to this day where a lot of these operations still are. They followed the poor people who didn't have access to the power, didn't have access to lawyers, didn't have access to that. And now who's getting silicosis now? Mainly Hispanic workers in the United States working on phony granite and marble tabletops, which some of you may have heard about, a very hot issue. And again, it's the lower levels of the economic ladder. Same thing in the environmental world. I'm on the East Palestine train derailment case. Some of you may have heard about. That's one of the cases I'm involved in. That's a predominantly white neighborhood.
I need to cut you off. Gary, I'm so sorry. I'm so sorry, but I know because I'm super interested in what you're saying, but we are past time, right? And just there. I mean, there's so much to talk about. I want to thank you both very, very much for this. I really do feel like there are hours of conversation that could have. Rob, can I turn it over to you to just close us out? And again, with apologies for cutting you off, Gary. So
well, thanks to everyone. I really enjoyed this. I learned a lot. I hope other people did. And I put in the chat the link to recordings of past Be Heard seminars and to the seminar for next month on using social media.
great.
Thanks so much.
Thanks, everybody. Take care.
Bye.
Thank you.
Bye.
Thank you.